Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-1038, Cboe Futures Exchange LLC petitioner versus Securities and Exchange Commission. Mr. Greenwald for the petitioner, Ms. McKenzie for the respondent, Mr. Stansel for the intervener.
Morning, counsel. Mr. Greenwald, please proceed when you're ready.
Thank you, Your Honor. May it please the court, my name is Paul Greenwald, and I represent the petitioner in this appeal, the Cboe Futures Exchange. This appeal really boils down to one issue. Does the exemptive order, standing alone, satisfy the APA standard requiring that the commission engage in reasoned decision-making? The answer to that question is no. Instead, the exemptive order is arbitrary and capricious for at least three reasons. First, the order does not provide a factual basis explaining why the spikes product must be exempt from the definition of a security future in order to achieve the commission's stated goals, which are fostering competition and lowering transaction costs. That failure alone is fatal under the Administrative Procedures Act. Second, the commission failed to consider two important aspects of granting exemptive relief. The commission found that the spikes product is a security future. And as the panel knows from our briefs, if something is a security future, the regulators have determined that specialized disclosures must be provided to investors before they can trade that product. The commission, however, did not address that issue at all. It didn't address whether the effect of granting exemptive relief would mean that investors would not be provided with the specialized disclosures that both the Securities and Exchange Commission and the CFTC have endorsed and have said must be provided to investors. The commission also failed to consider the fact that its order and the fact that it decided to proceed alone and not engage in joint action with the CFTC would lead to regulatory confusion. We have a situation here where the Securities and Exchange Commission has said the spikes product is a securities future, full stop. And it made that determination despite the fact that MGEX, the exchange where the spikes product is traded, urged that the product be viewed as a regular future. In other words, it did not agree with MGEX on that position.
Mr. Greenwald, do you believe that the SEC has the authority to exempt spikes without working jointly with the CFTC?
Your Honor, I do. There is a statutory scheme of joint regulation for security futures, but there's also Section 36 of the Exchange Act, which I believe, despite Congress's intent that security futures would be jointly regulated, I do think that allows the Securities and Exchange Commission to go it alone and to exempt products solely for the purposes of exchange.
And so you think it's consistent with the Act for both agencies to reach different conclusions about what is a security future?
I do not.
And for the SEC to separately exempt, a security future from their rules?
I do not think it's consistent with the statutory scheme for the agencies to reach different conclusions about how a product should be classified. I do think, though, again, under Section 36, that the SEC does have the authority to exempt even a security future from certain Exchange Act requirements, if that answers Your Honor's question. So we have a situation here where the SEC has said these products are security futures.
Can I just ask you, so you started out by saying, I think, that you have to look at the order alone?
Yes, Your Honor.
And the question is why? So suppose if the order alone gives an indication of what the explanation is, and then all you have to do is look at the underlying record materials and it's readily apparent what the only explanation could be as to why the exemptive order was issued. Does it make sense just to send it back for what everybody knows is going to happen? It might, but I'm just framing the question that way to get your answer on why is it that you would never look past the four corners of the order itself?
Well, I think they have to at least give some indication of the rationale behind their decision. That is required by Section 706 of the APA and this court's precedent. So I don't think it's sufficient to go back after the fact, as counsel has done in their briefs, come up with rationales that aren't discussed in the order and say, this is what the commission certainly had in mind.
And what do you mean? What are the rationales that you say aren't discussed in the order at all?
Well, for example, their briefs talk about tax treatment of this product. The exemptive order doesn't mention tax treatment whatsoever. And we think there's a real issue as to whether or not the SEC, by granting exemptive relief for the purposes of the Exchange Act, can change the tax treatment of this product. In fact, the section of the Revenue Code that the Commission cites in its brief, Section 1234B, essentially says, and this is 1234B subsection C, something is a security future if it meets the Exchange Act definition of a security future. The Commission has said it does meet the Exchange Act definition of a security future. The next provision, D, says if something is a security future, it's taxed as a security future, not as a regulatory future. So that's an example of where we believe that counsel on appeal has created a rationale that is completely missing from the exemptive.
Well, suppose the SEC said that in its order. Suppose it said, it did reference promoting competition. And then the next layer is, well, why does it promote competition? And it could be, well, it promotes competition because it creates a more equivalent tax treatment. And then there'd be a subsequent question that you're pointing out, which is, does it actually create a more equivalent tax treatment? Because maybe the IRS thinks that actually it's not, you can't do this, that it doesn't result in the same tax treatment because you've already denominated a securities future. That's a separate question. But suppose the SEC in its order did do the second part, which is to say, promote competition. It did say that. Why does it promote competition? To equalize tax treatment. And it explains, we think it'll equalize tax treatment because even though we denominated it as securities future, we think really the fact that we're doing the exemptive part of it kicks it back and makes it roughly equivalent to VIX. And then there'd be a separate question later if that's correct or not. I get that. But if they had done that second part, would that be enough to survive arbitrary and capricious review for this part of your challenge?
I don't believe it would. I think the case law is clear, including the Susquehanna case, which we believe is squarely on point. It's not sufficient for us to speculate about what the agency might have done.
No, but they didn't.
Wishes it had done.
They didn't. I'm giving you a hypothetical where we're not speculating anymore, at least as to the rationale for thinking that it's promoting competition is that it would equalize tax treatment. I'm hypothesizing an order in which the order actually says the reason that we think competition would be promoted is that tax treatment would then be equalized. So that part of the explanation is actually in the order by hypothesis. I know it's not in there now, but by hypothesis it's in there. So why wouldn't that be enough?
I think they would have to explain why, under Your Honor's hypothetical, that it would equalize tax treatment. And they would have to deal with the very statutory provisions that I just dealt with, or just explained to the court that, and they would have to explain why they think they have the authority to alter the tax treatment under the Revenue Code. And we don't think they have that authority.
Is there anything in the record that suggests that even if that the SEC could do this, or that by creating this exemption, it affects the tax treatment of the SPICE futures?
Is there anything in the record? There are statements by MJEX referring to tax treatment and the need to equalize it, but there's nothing in the exemptive order. And they are just conclusory statements, even in MJEX's submissions. So there's no analysis there of the tax code or the Commission's authority to alter the tax code and affect the tax treatment. And again, by finding that these products, the SPICE product is a security future, we think that locks in the tax treatment under Section 1234B.
Right, you think that, but so then just get back to my hypothetical. So suppose they say, I want to get to some point at which it would be enough, because there has to be some explanation that would be enough as to the tax treatment, even if it turns out, maybe you disagree with this, even if it turns out that it's legally wrong. If they believe that it will equalize the tax treatment, or if they think it's likely to equalize the tax treatment, they being the SEC, obviously, they create an order that says, I'd like to promote competition. The way to promote competition is to equalize things as much as possible. One of the key criteria is tax treatment, because there's a disequilibrium unless there's equivalent tax treatment. We think it would equalize tax treatment. Here's how we analyze the provisions. It would actually equalize tax treatment in our view. That may turn out to be wrong, but that's our view. If they spell that out, then would that be enough as to this part of it?
I think it would be enough as this part. I think the appeal would be different than we would contend, we would be arguing that they got it wrong, essentially. But here we have a different case. We have the absence of any analysis. So if they engage in the analysis and get it wrong, I agree, Your Honor, that is a different.
And in Judge Srinivasan's hypothetical, would that be then a contrary to law challenge that you would bring?
I think it would be contrary. I see I'm out of time, so unless you have other questions, I'll sit down and reserve my time for rebuttal. Thank you.
Thank you. Ms. McKenzie?
Good morning, Your Honors. May it please the Court, Rachel McKenzie for the SEC. There's no dispute in this case that the classification of these products and how they trade, whether as a security future or as a future, carries competitive consequences. 20 years ago, Cboe sought and obtained relief so that its own product, VIX futures, would trade as a regular future rather than as a security future. And the Commission said enough in this order for this Court to discern that it granted conditional and exemptive relief to MJEX to level the competitive playing field so that spikes futures.
Can you maybe just give me some background here? Why did the SEC and CFTC not coordinate as they did with the VIX futures? What was the, there's a very strong directive from Congress for security futures to be coordinated between the CFTC and the SEC. And that's in fact what happened with VIX futures. So why did the SEC go it alone here?
The agencies disagree on whether or not, under the statutory terms, this product is a future or a security future. They reach different conclusions about that, as they're permitted to do under the statute. The statute grants concurrent jurisdiction. It requires the agencies to coordinate in certain particular ways. For example, as in the VIX order, if they're going to exclude an index from the definition of a narrow-based security.
The fact that Congress gave the same exact definition in both acts and strongly, in a number of provisions required coordination. Is it actually consistent with the act for the agencies to reach two different conclusions about whether the same product is a security future? How does that help, how does that help, people who are buying this product or people who are running this product? How does that work?
I think it is, Your Honor, because the Congress gave the agencies concurrent jurisdiction, it certainly didn't give the CFTC unilateral authority to decide whether something is a security or not, nor did it give the Commission unilateral authority. And essentially what happened here is the agencies proceeded consecutively rather than concurrently. But at the end of the day, they reached roughly the same conclusion, right? The Commission disagrees with the CFTC. It does think that this product meets the statutory definition of a security future, but it also recognized that practically speaking, there are reasons why it is appropriate to treat this product the same way that you would treat VIX futures, and that is that it trades fundamentally as a future rather than as a security future. I don't think the Commission in this case created regulatory confusion. I think it eliminated it. CFTC went through its process. It determined that this should trade as a future. The Commission hadn't spoken at all. And then when it weighed in, said, we actually think this is a security future, but at the end of the day, we also think it should trade as a future rather than as a security future.
So apart from the regulatory confusion part of it, although if you have a follow-up, I don't want to me, there's a threshold question, which is that the order links the public interest to fostering competition, in the words of the order. But then it doesn't say anything about how competition is fostered. It just doesn't. There's nothing in here to explain how competition is fostered. And I take it from the briefs, the argument is essentially, well, self-evident. Of course, competition is important, and that we can probably take as a given. But how does this foster competition? And the briefs have an explanation about margins and taxes, and we'll focus on taxes because at least taxes are in the record. But there's not the link in the order to any of that. That just seems like a problem because it leaves somebody wondering what the agency's explanation is as to why the public interest is being served. And it's incumbent upon the agency to explain it. It might be easy for the agency to do, but the order just doesn't contain that explanation.
So a couple of reactions to that, Your Honor. First of all, I disagree with the premise that the order doesn't say anything that suggests that these classifications matter for competition. Specifically about the margin requirements, that actually is in the order at Joint Appendix 4. The Commission specifically exempts MJEX from requirements for listing standards. including with respect to margin, because given that the order is going to allow it to trade as a future rather than as a security future, it would be improper to hold them to the same listing standards for security futures. So the margin piece is actually in there. Secondly, the order also at footnote 35 notes that the statute itself recognizes that these regulatory classifications matter for competitive purposes because the statutory definition of a narrow-based security index in Exchange Act Section 3855 includes a 3-month grace period when an index is going to transition from broad to narrow-based, i.e. when a product is going to transition from being a future to a security future. There's no dispute that this classification matters deeply to market participants and that matters in a way that affects how customers behave.
There's no doubt about that, but let's just focus on taxes because that's been a big part of this. Is there anything about taxes in it?
Not in the order. No,
okay,
it is in the record.
It's in the record, right? So you have to, and particularly it's in, I don't know, I already said VIX when apparently I was supposed to say VIX, so I don't know how I display. But the intervenor, it's in the intervenor's materials when they made the application to the commission. But you can't look at the order and know that it has anything to do, that competition is fostered because it equalizes tax treatment in the view of the commission.
Right? I agree with that, Your Honor. I don't think that particular piece is necessary to be in the order for this order to survive arbitrary and capriciousness review for this reason. The commission focused on the ways in which these classifications are different and matter, and that is consistent with the commission's expertise and what it particularly has control over. So that's the listing standard and margin requirement. As Your Honor's colloquy with Mr. Greenwald indicated, ultimately the question of tax treatment is for the IRS. The commission's statement that this should trade as a future and not as a security future is a necessary condition for MGX to get the tax treatment it would like. It may not be sufficient, but that doesn't undermine the fact that it is necessary.
Your whole brief, you have a lot, I'm sorry. You have a lot of stuff in your brief about tax treatment, and I think, right? And now it's sounding to me like none of that matters.
It matters, Your Honor. It matters that it's in the record. What the order says enough for this court to discern the commission's path, that it reached this conclusion because these regulatory classifications carry competitive significance. The order highlights one reason why that's true, that's the listener requirements, and this court can turn to the record in judging the reasonableness of the commission's decision and see another reason why that's true, and that's the tax.
Well, Ms. McKenzie, how do the listing requirements relate to competitiveness? It seems like the real gist of making them competitive is the tax treatment. I mean, listing requirements don't necessarily affect the competitiveness for consumers. So I'm not sure how that gets you to, how does that get the SEC to supporting its claim that this is necessary for competition?
I see my red lights on. Can I answer Your Honor's question? The listing requirements as to margin do matter to customers because what margin essentially means is the higher the margin requirement, the more a customer has to pay up front to take a position.
But the main competitive difference is the tax treatment.
That's a significant competitive difference.
Do you have a sense, how is the IRS treating, what sort of tax treatment has been given to these futures over the past, year and a half, 2 years?
I actually do not know that. My colleague who is going to be speaking for MGX next might have a better sense of that because it's MGX's customers that would be requesting that treatment.
But you agree that the SEC cannot exempt securities futures for the purposes of the tax code?
It can't reach a determination about their tax treatment. What the commission did in this case is what it's authorized to do, which is exempt for most purposes this product from the definition of a security future and state that it is the commission's intention that this trade predominantly as a future, not as a security.
But that also means that the commission believes that this is a security future and for some purposes regulates it as a security future.
For some limited purpose.
And you agree that the SEC cannot exempt these from the tax code because presumably the SEC doesn't have any exemptive authority over the tax code. Certainly agree with that, Your Honor.
What we have the authority to do is exempt this product from a definition. And as my colleague for Mr. Greenwald noted, the tax code depends on how this product is defined.
Well, but you've already said the CFTC can have its own definition, so presumably the IRS can have its own, understanding of what a security future is. And I actually think the way the SEC has structured it is that the SEC believes it is a security future and then creates exemptions, but you've defined it as a security future. So it's hard to imagine then why it would also be exempted, why it would get the type of favorable tax treatment you're assuming that it will get in order to promote competition?
Because the commission stated clearly in its order that the intent is for this product to trade as a future and not a security future. I do just want to, if I may, briefly roll back to the issue of the CFTC and its determination. I think deciding that the commission couldn't come to a different conclusion creates some issues here, because essentially because the CFTC went first, the situation that arises is that if the commission disagrees with the CFTC, as far as Cboe's argument goes, that it only has two choices. It can either say, we agree with you that this is a future and cede all of its jurisdiction, or it can say, we don't agree with you, this is a future, we think it's a security future, but then we can't grant any exemptive relief to allow these things to practically work.
Of course, is a big problem with independent agencies, right? Because if these agencies were under the control of the White House, then there would be some uniformity. It's not clear how two historically independent agencies are supposed to coordinate for the benefit of consumers and the public in a way that Congress has directed them to do.
Your Honor, I do want to emphasize that the agencies do coordinate substantially. We did have discussions about this particular issue. In this particular case, we were not able to reach an agreement as to whether or not this was a future or security future, but we worked it out. This is exactly the way government agencies should behave. We have a disagreement about what the statutory language means, but we came to a practical solution that's mutually agreeable to both the CFTC, SEC, and MJAX. I realize Cboe challenges that, but I think the practical result here is exactly what you would want to see.
I mean, you came together with VIX way back in the day, I guess, right?
That's correct.
More so than here, even though I take the point that the ultimate conclusion here, in your view, is more alignment than in disalignment. So on the tax part of it, if the SEC, seems like you agree, the SEC can't dictate tax treatment by virtue of its classification, but it can predict tax treatment. That's essentially what's going on. It thinks that even if it classifies it as a securities future, because of the exemptive part of it, and because the goal is to treat it as a future, the assumption on the part of the SEC is that then it will gain futures tax treatment by virtue of how the IRS chooses to treat it. That's what's going on.
That's right, Your Honor. I think it's a reasonable expectation that it will get this tax treatment. It's a necessary precondition to it getting to that tax treatment. Whether or not it actually happens, we don't know, but we're not required to be able to perfectly.
So is that the type of thing, it's not in the order? Is your view that the SEC, it would have been irresponsible for the SEC to put that in the order because it doesn't have authority?
No, Your Honor, I don't think it would have been irresponsible for the SEC.
So it could have. It could have done the explanation.
Frankly, there's a practically limitless amount of detail that the commission could have put in this order. I think the question is what it's required to put in the order.
Right. And so it could have done that.
Yes.
And it just didn't, there's not a word about tax treatment.
That is correct.
Yeah. Okay. Can I ask you, so the order does say in linking the statutory goal of public interest to the explanation for the exemption, it does say what it's going to do is foster competition. That's the way in which the public interest is furthered, I assume.
Yes.
So what if the order didn't say that either? It talks about the public interest, but it doesn't say anything about facilitating greater competition or foster competition. Would that be okay? Because someone could say, well, everybody understands, of course, this is a competitive landscape. Just look at the history, look at VIX. Everybody knows what's going on. Look at MJAX's application. That's obviously what's going on. The order didn't have to say that. Just assume it to be true because, of course, that's the backdrop against which the commission acted.
So I think if Your Honor's hypothetical is essentially, if this case, it's just that the commission has just said the standard under Section 36 has to be in the public interest and consistent with investor protection. We find that this meets those, and so we're granting exemptive relief.
And then we have some conditions, and
right.
We'll spell out all the conditions.
I think that would be a lot closer to what this court was dealing with in Dixon and in Butte County and Taurus records. It would be a much closer case than this one, but I think in this case, the commission did provide its rationale for why it made that ultimate finding that this was consistent with Section 36.
And that's the foster competition. And
that Spikes Futures would need to trade, clear, and settle as a futures contract rather than as a security future to serve as an alternative to the only comparable incumbent volatility product. Yes.
And what if there was no reference to, I mean, you pointed out something about listing and margins. If there weren't that,
It's a good question, Your Honor. I'm not sure that the commission is required to go deeper than this is necessary to foster competition. These things need to be comparable, so they need to have the same regulatory treatment. But this order does go that extra step and points out one way in which these different regulatory.
That's the listing point on JA4.
And it also, again, points to the fact that the CFMA itself in the Exchange Act indicates that these classifications matter deeply to market participants. If there are no further questions. Thank you, Your Honor.
Thank you, counsel. Mr. Stansel.
May it please the court, Mark Stansel for intervenor, which we call MJEX. I'd like to address two primary points subject to the court's questions. First, I'd like to explore this competition issue in a little more detail and explain why we believe that the commission's order and ultimate conclusion is rock solid, that this product, proving it to trade as a future, was absolutely essential to competition. And second, I'd like to spend just a minute on the practical reality of awarding any remedy here, but in particular the vacatur remedy that Cboe was seeking. So first, Your Honor, let me start by addressing competition, and I'd like to start maybe by pressing back on your premise that the order doesn't explain basis for the competition finding. And part of the reason that it doesn't get a lot of discussion in the order is because not a lot of discussion is required. So Cboe's primary attack in its brief is to try to redefine the market, to say, well, the market here is volatility in the S&P 500. Well, that's not correct, and that's not how the commission defined competition and the relevant market in its order. Here's what it said. The commission said, first, it defined MJEX's request as—
Where are you reading from?
This is JA1. It's literally the first paragraph of the order. It says that MJEX has asked, the request seeks permission for listing and trading contracts for sale for future delivery on the spike index. And then concludes that the product has the potential to offer competition with the only comparable only comparable incumbent volatility product on the market. So the commission defines the question as S&P volatility futures. And I'm going to spend just a second trying to explain the difference between futures and what Cboe suggests would be other potential alternatives. It's apples to oranges. So Cboe says that actually the question is just S&P index volatility generally and suggests ETFs, ETNs, options, things like that. In the financial world, which is a little esoteric, I grant you, that is like, I use the produce analogy, apples to oranges. It's like apples to celery to rutabaga. An option has a very different market dynamic. It's used by different investors. Futures, volatility futures are used by institutional investors and have a totally different risk profile. So until a few weeks ago, or a few months ago rather, I'm not sure I would have known the difference, but to people in the industry, this doesn't require explanation. And what is undisputed is that there is, before the spikes product, one and only one, the VIX future in that market. And that's because they have an exclusive license from S&P.
So, Mr. Stansel, even if we assume that competition is of real importance here, that assumption of the SEC is correct, I mean, why does MJEX not challenge the SEC's threshold determination that the spikes future is a securities future? Well,
we did try to persuade them of that, Your Honor. Mm-hmm. The way, if you recall, what happened was we self-certified with the CFTC that this was just a future. The commission objected. We pulled the product and spent the better part of a year trying to persuade them. But they do have this exemptive authority, and I think my colleague is quite correct.
The main reason that you cite in your brief for the need for the exemptive authority is the tax treatment. So I'm curious, I mean, what has been the tax treatment over the past year plus?
My understanding is they are taxed as futures, and I think that's consistent with the definition. I'm no tax lawyer, but I think it's consistent with the definition of a 1256 contract. But I grant you, something would have to give, and there's nothing in the statute that says that the commission can't exercise its exemptive authority to preserve its opinion that these ought to be futures, but to trade as futures contracts. So when something trades as a futures contract, it goes to a specific kind of exchange regulated by the CFTC in the day-to-day. And so that is my understanding of how these things are in fact treated in reality. But
And this exemptive authority has, in the real world, created the tax consequence that your client is seeking?
yes, that's my understanding. The reason, Your Honor, if I may continue just a moment, the reason that they don't have to go deeper into competition is because we're really at day one of introducing any competition into the futures volatility market. So it doesn't require a lot of explanation to say it is better to have two genuine competitors than one. That is why, with respect, I think
Right,
it is self-evident.
but that part of it may be self-evident, but then there's the question of why does this make them genuine competitors? And that's because tax treatment, that's the main one.
Well,
right?
But respectfully, Your Honor, if it's a futures product and trades as a future, then it is a competitor. It would also require so if you treat it as a security future, it will not trade on a futures exchange.
Mm-hmm.
So they're literally, and Cboe cannot point to any. There is no such thing as a security future product for S&P volatility, or the thing just doesn't exist for this reason. So could the commission have explained, that it has to trade as a future? They did. Do they have to go the next step and say, here are all the consequences of that? I don't think so. There is an additional point in the order.
Would that be helpful?
Sure, it would be helpful,
Okay.
but I think Your Honor, in the context of an informal adjudication, as the commission has explained, I don't think they're required.
No, I don't think they have to do everything that's helpful. I just want to make sure I understand your argument that it actually would have been helpful to do that.
Yes, but I would also point, Your Honor, to page 3 of the joint appendix, in which the commission also explains that adding second product, this is, I don't know if you all look at the first column on the left, 8 or 9 lines down, it says, in addition, the introduction of an additional volatility product in the market should lower transaction costs for market participants. That was a big part of the submission. May I spend 30 seconds on the remedy issue? Or
if it's 30 seconds, yes.
Thank you. I just want to explain how competition works when trying to dislodge a monopolist. So having an S&P volatility futures product is one step of a multi-step, multi-year process. And it is hard to dislodge an incumbent that's enjoyed an 18-year monopoly. So a remand, we think, is not necessary, but a vacatur would be catastrophic. It wouldn't just set us back 30, 60, 90 days. It could have set us back years with great injury to competition. And if Your Honors would just flip at some point to JA 87, which is in the sealed appendix.
But I mean, the fact that there are consequences to vacator doesn't mean, we don't just remand without vacator because it would be difficult.
No,
for one of the parties. I mean, if we found that the order is arbitrary and capricious in some important way, then isn't the ordinary remedy to vacate?
Ordinarily, yes, Your Honor, but not where doing so would actually undermine the purposes of the act itself and where the authority.
That's not our standard, though, for remand without vacator.
Correct, Your Honor. I think it's an allied signal. I think it would be entirely disruptive to the market. There are enormous reliance interests on not only our product but on regulatory clarification of this area. So I think if under the ordinary reliance factors, I think it would be incredibly disruptive. It would dislodge pricing improvements that have happened in the market. There are people who are relying on our product. There are products that in turn rely on our product. So we would be unscrambling a lot of eggs. And I think that is in the core of why the court would.
Can you just practically spell out the reliance? I mean, that's because of the nature of a future, that it's by definition forward-looking. So people have made transactions in reliance on the regulatory treatment as, although classified as a securities future, trading as a future.
Absolutely, Your Honor.
And it would undo those expectations.
Yes, and so, for example, when this product first came on in 2019 and started to trade, it required, I think, all of somebody's Thanksgiving holiday to try to unwind even the first day of trading. And here, we're talking about 2 years of product, but then also there are, I believe, ETFs that incorporate the spikes volatility future product in that ETF. So it's not just our product, it's products.
They're derivative of this.
Yes, derivative of a derivative.
Yeah.
If the court has no further questions.
Thank you, Mr. Stancil. Mr. Greenwald, we'll give you 2 minutes for rebuttal.
I'd reserve 3, but
I think you'd used up some of that already.
A few points, Judge. First, there was mention by Ms. McKenzie of agreement between the agencies to disagree. There is nothing about an agreement between the agencies or discussions between the SEC and the CFTC in the record in terms of what the CFTC's position is. And the CFTC has not stated a position as to whether or not this product is a regular future or a security future. There was also a lot of discussion by both Ms. McKenzie and Mr. Stansel about competitive effects and competitive analysis. And I'd just like to remind the panel, again, there is no competitive analysis in the exemptive order itself. There's no definition of the competitive market. Council and I may disagree about what the competitive market should be defined as, but the reality is the exemptive order says absolutely nothing about the issue. And in fact, it doesn't even refer to the VIX futures by name. With regard to the tax treatment, Ms. McKenzie conceded, I think correctly, that the SEC can't determine tax treatment, but their briefs are all about tax treatment. And then their argument turns into, well, don't look at the order, look at the record on tax treatment. And that argument is directly contrary to the Supreme Court's holding in the State Farm case, the Motor Vehicle Association case, where the court said you can't look beyond what the agency has said to the record and come up with justifications to support the agency action. And finally, with regard to the vacator versus remand remedy point, again, there is no evidence of a catastrophic market effect that would occur if the exemptive order were vacated. In fact, the evidence is directly contrary. In 2019, MJEC shut the product down on 1 day's notice when the SEC presumably said, what are you doing? We think this is a security future. Why are you trading it as a regular? So there is no evidence of a catastrophic market.
But how long had it been happening at that time?
It had been trading for 2 weeks. But remember, these are futures, Your Honor, so they trade to expiration. Contracts continually expire. And although it's outside the record as well, and I'm leery about going outside the record, there is not a significant open interest historically in the SPICE product. It's not something that is heavily traded.
So, I mean, well, for this part of the inquiry, I think almost by nature, we have to go outside the record to some extent because no one's going to have created a record that's geared towards the question of vacator, I don't think. So what would be the practical consequence of a vacator in your view? You think it would be, there would have to be transactions that would have to be unwound, I take it. Everybody agrees.
Well, they would have to close their positions out. They would not be able to open any new positions, and they'd have to close their existing positions out, which is exactly, presumably, what happened in 2019 in 1 day. The record is that the SEC asked MJEX to stop trading on November, I think, 28th, and they stopped trading on November 20th. So again, the idea that this should continue trading pursuant to an exemptive order that is invalid because of some catastrophic market effect, there's just no evidence of that.
All right. Thank you, counsel. Thank you to all counsel. We'll take this case under submission.
Case number 21-5250, Chava Rachel Mark, individually and as parent and natural guardian of CBM, RLM, and EBM minors et al. Appellants versus Republic of the Sudan and United States. Mr. Perlin for the appellant, Mr. Kern for the appellee, Ms. Carson for the intervener.
Morning, counsel. Mr. Perlin, please proceed when you're ready.
Your Honor, may it please the court. Mark's family has said from the beginning of the case, the outset, that they do not challenge the government's authority to settle claims. What they challenge is the government's authority to do so in an unconstitutional settlement. That's what this case is about. It involves an unprecedented settlement agreement entered into between the United States government and Sudan, in which certain claimants were compensated, provided were allowed to continue their cases, or both, and only the Marks and a small group of similarly situated claimants were denied any benefits of the settlement agreement. They lost their claims. The claims were espoused and settled for the benefit of the other parties. I haven't seen any precedent of a settlement that goes that where the benefits are distributed so inequitably.
Mr. Berlin, in understanding your argument, your equal protection argument, are you making the argument that the jurisdiction stripping here violates equal protection, as well as the substance of the claims settlement violates equal protection? Because I see those as two distinct claims.
There are two claims, but the crux of the jurisdiction stripping claim is that it was done in a way that violates equal protection.
Right.
So
it seems that we have to first address whether the jurisdiction stripping violates equal protection. Because if the jurisdiction stripping provision is constitutional, then we lack subject matter jurisdiction.
Well, there are two ways in which the jurisdiction stripping provisions can be unconstitutional. Mm-hmm. One is based on access to courts, mm-hmm. and one is based on the disparate treatment of certain claimants versus others. The 9/11 claimants were given leave to continue their cases, and they were compensated under the settlement agreement.
But that just goes to confirm, I think, what the premise of Judge Rao's question is, which is that in order to go forward in any way with this case, we'd have to first conclude by your own argument that the jurisdiction stripping provision is invalid. Because if it's not, then we lack jurisdiction.
I'm not sure. What happened here was what happened first was that the executive branch entered into the claim settlement agreement with Sudan. And in that agreement, they espoused and settled all claims. The jurisdiction stripping provision is more forward-looking. I mean, the claims of the claimants with any pending case were terminated with the espousal. Jurisdiction stripping claims provisions are, as to pending cases, it's piling on, and as to future cases, I think that's what Congress is looking to future cases by stripping jurisdiction and terminating the cause of action, statutory cause of action. It also applies to the pending cases. But I think the first step here was that the government espoused and settled all cases.
Right, but for our purposes, that was the first step chronologically for purposes of what happened to your claims. But for our purposes in addressing what we can do with your challenge on appeal, don't we first have to decide whether we have jurisdiction? And the only way in which we don't have jurisdiction, because the statute purports to reconstitute Sudan's sovereign immunity. Right. And for us to be able to address your claims at all, we have to conclude that that was invalid. Otherwise, we lack jurisdiction.
Okay, so let me address that, because the jurisdiction stripping provisions are invalid for a very fundamental reason under equal protection. And it's important to keep in mind the background of the FSIA. Before the FSIA was enacted, the executive branch would settle cases ad hoc. There were no standards governing what cases were, the government would grant or waive immunity on an ad hoc basis. There were no standards determining which cases were allowed to proceed, which cases were not allowed to proceed. It was just a suggestion by the government, this one can go, and the courts would defer, and where these ones can't, there are no standards. The Congress enacted the FSIA to set firm standards so that all U.S. nationals would be treated equally in their claims against foreign states. The Supreme Court characterized the before and after the FSIA as, it said that with the FSIA, the Congress abated the bedlam. And it was arbitrary and capricious which cases were allowed to proceed and which were not. This settlement agreement It's a throwback to the pre-FSIA standards, which
But
didn't.
the
there were no standards.
FSIA world didn't violate the Constitution.
Correct. It didn't.
So if Bedlam was not unconstitutional and the executive could act in perhaps arbitrary ways in deciding, when they were going to suggest immunity was going to be waived or not for foreign sovereigns, in Congress provided some standards with the FSIA, how is it unconstitutional for Congress to change the standards, even if they change them in some way that goes back to some degree to the Bedlam that we had before?
So, Your Honor, Bedlam was not per se unconstitutional, but Bedlam could be unconstitutional as applied. And that's what happened. That's what's happening in this settlement agreement. That the government threw away all standards, determining that there should be some standard basis for determining which claims can proceed and which claims can't. And they did it within one case where in one scenario where all of the claimants are similarly situated. They're all U.S. nationals with terrorism claims against Sudan. And the government said, you and you and you and everybody can get paid or maintain their claims or both, but these plaintiffs cannot. We're going to trade in their claims for no benefits, but to the advantage of all the other claimants.
Mr. Ferland, do you agree that the equal protection standard here is rational basis?
I think it has to be heightened. In the reply brief, discovered, it's unfortunate I didn't discover it earlier, but I was in the motion to extend the time. It was in the reply brief that the reasons, the rationale offered by Sudan and the government was patently false. The primary basis for the district court's decision was that all of the claimants who were compensated had either obtained a default judgment or were the beneficiaries of a private settlement agreement with Sudan. Sudan went so far to say that the U.S. government had no part. There was no government action, governmental action in these private settlement agreements. But Sudan cited a press release that says the government did have a role in the private settlement agreements. What that does, the disingenuity of the proffered rationale for the distinctions I think it throws into doubt every rationale offered, because if they had a valid reason to distinguish, they wouldn't make up reasons that defy the fact.
Is that an argument that the government's reasons don't pass rational basis review? Or that, are you arguing that the bad faith of the government or misrepresentation somehow requires to impose a heightened standard?
It requires a heightened standard of review because there's no basis to evaluate the rationality of the decision when the police are offering deceptive rationale, and meaning if there was a good reason for the distinction, they wouldn't be forced to offer patently false reasons that are demonstrably false. There were no private settlement agreements. These were agreements that predated the signing of the claim settlement agreement. They were orchestrated by the U.S. government. And I mean, look at it this way. There was one group of plaintiffs, the Tate plaintiffs, came in 20 years after the Cole attack and filed their claim. They were represented by a very well-connected law firm, and they filed it a few months before the Marks filed their claim. Just a few months before the Marks filed their claim. The government claims, and Sudan claims, and the district court found that the Marks came in at the 11th hour, were being opportunistic. Nobody said, oh, maybe the state plaintiffs are being opportunistic, or the law firms being opportunistic, or they were the ones who orchestrated the private settlement agreements with the U.S. government. I think that it requires scrutiny. It requires a closer look because of the deception. I requested 3 minutes.
We'll give you a little bit of time for that.
Okay, thank you.
Thank you, counsel. Mr. Curran.
Please the court, Christopher Curran of White and Case on behalf of the Republic of the Sudan. This morning, I'm accompanied by, among others, the Sudanese ambassador to the United States in the gallery. Ambassador Idris presented his credentials to President Biden earlier this month. The ambassador's counterpart, U.S. Ambassador John Godfrey, has arrived in Khartoum, where he has presented his credentials. He's the first U.S. ambassador to Sudan in over a quarter of a century. This historic normalization between two nations that were formerly contentious was made possible only by the claim settlement agreement and the statute that's at issue in this action. Sudan, and I think everyone, has great sympathy for the horrible incident that and the tragedy that befell the Marks family. But the district court was correct to dismiss the action against Sudan. Under the Supreme Court decision in Rurgas, the district court had some optionality as to how it would address the claims. And the choice was between addressing the subject matter jurisdiction argument that hinged on a constitutional challenge or the political question doctrine. And the district court went primarily on the subject matter jurisdiction and constitutionality argument, but also tipped its hat to the political question doctrine. This court, I suggest, has the same optionality under Rurgas in choosing how to affirm the dismissal below. As to the constitutionality point.
Do you think we do have that optionality? I mean, we have before us, both parties agree that there's a statute that strips us of subject matter jurisdiction in this case. So don't we first have to decide that as a threshold issue about whether that jurisdiction stripping provision is constitutional? So in some cases, we have the option to choose one jurisdictional ground over another. But where there is a statute explicitly divesting us of jurisdiction, don't we have to address that first?
I understand the question. First of all, there's no question this court has appellate jurisdiction under 1291. As to the district court's subject matter jurisdiction, yes, ordinarily it is incumbent upon a district court to address subject matter jurisdiction at the outset. But I think Rurgas, in clarifying the Steele Code decision, was quite explicit in saying that when a district court has various threshold options to dismiss an action, it may choose among those threshold options. Just as this court did prior to Rurgas, and in a case cited in Rurgas, the Papandreou decision, where this court concluded that it could dismiss an action on forum nonconvenience before determining, or it concluded that district court could dismiss an action on forum nonconvenience before addressing subject matter jurisdiction. So there are circumstances in which a court is excused from making a definitive ruling on subject matter jurisdiction when there is another, perhaps easier threshold basis for dismissal.
Is it your contention that political question is an easier grounds for affirmance?
Sudan doesn't take a position on which is easier. We're agnostic as to which approach this court takes. We think it's clear under both arguments. We think that the constitutionality is clear here because it is a rational basis standard, and we think that there are, we easily pass that for a variety of reasons. And we also think that under existing precedent, the political question doctrine would also be a viable way to affirm the dismissal. And for that, I cite not only the Federal Circuit decisions in aviation and in Belk, which were pretty close to on point to our scenario here, but also the more recent Supreme Court decision in Rucho, which found that it was appropriate not to address equal protection claims on the basis of the political question. So whether this court is inclined to go with the constitutionality route, as the district court did, or political question, we have no position on that. We think either is a viable basis for affirmance.
And you haven't made any argument to the effect that if on the first route, that it's inappropriate to entertain a constitutional challenge to a jurisdiction stripping provision. Your argument all along has been, oh, sure, there's such thing as an equal protection challenge to this. It just fails because it survives, because the statute survives rational basis.
Well, that's correct. This is an unusual case in that the subject matter jurisdiction issue turns on a constitutional issue.
Right, because of the nature of the challenge.
Right.
But you've never suggested that there's some impropriety in entertaining that constitutional challenge to the subject matter jurisdiction stripping provision. You've bought into that. Your point has been, and the district court accepted it, that the equal protection challenge lacks merit because there is a rational basis for the lines that Congress drew in the statute.
That's right. And I fall back to Rurgas on that point. I do think that a district court has an option as to choose between those threshold grounds.
You know, it's not clear to me exactly what the district court did here, because the district court seems to address the substantive merits of the equal protection challenge to the statute. And then after that, saying that the statute, in the way it allocates claims, doesn't violate equal protection, then then turns to subject matter jurisdiction.
Or then turns to political question doctrine.
Well,
the way I read the opinion.
Do you agree that the plaintiffs here or the appellants have basically two separate equal protection challenges? One is an equal protection challenge to the jurisdiction stripping, and another is the equal protection challenge to the way the claims have been settled specifically?
I don't know. I don't know that I understand the plaintiff's argument to that extent. Certainly the latter. They're certainly claiming that they've been mistreated in the claim settlement agreement and in the implementing statute. And I think the district court addressed that.
I'm not sure that we can reach the substantive equal protection challenge to the statute before we reach the equal protection challenge to the jurisdiction stripping provision of the statute. I'm not sure any of our cases permit that ordering.
I read Rurgas as permitting that. Because
as before determining we have subject matter jurisdiction at all, deciding whether a statute is constitutional?
Because the constitutional issue is embedded in the subject matter jurisdiction issue here, right? Because
wait, which statute are we talking about?
Well,
an equal protection challenge to which statute?
Well, it's to the stripping. It's to the amendments to the Foreign Sovereign Immunities Act, right? That's what the implementing statute here did. It amended the FSIA. And the FSIA, of course, is the sole basis for jurisdiction over foreign states in all courts in the United States, federal and state. So here, the challenge, the constitutional challenge, was that the statute amending the FSIA was invalid due to unconstitutionality. So the equal protection argument is inherently or inextricably entwined in the subject matter jurisdiction question.
It's not just inextricably intertwined, it is the challenge. Because if the subject matter jurisdiction stripping statute is valid, the case is over because we lack jurisdiction. So there must be some basis for saying the reinstatement of Sudan's sovereign immunity is invalid, because if it's not invalid, we lack jurisdiction. And I take it the way this case arises is there's a challenge that's being made that says actually it is invalid. And the reason it's invalid is because there's an equal protection problem. Because it's the only way that Sudan's sovereign immunity got reinstated is by drawing lines in the reinstatement of sovereign immunity that don't pass muster under the equal protection clause. But am I misunderstanding?
No, that's how I understand the plaintiff's argument. Yeah, that the jurisdiction stripping statute, the Sudan Claims Resolution Act, is unconstitutional and therefore fails, in effect, to amend the FSIA.
And therefore, Sudan still lacks sovereign immunity. And therefore, the case can go forward.
That's their argument, because the implementing statute eliminated 1605 capital A, which was the sole basis for subject matter jurisdiction over these claims.
Any further questions? Okay.
Thank you.
Thank you, Mr. Kern. Ms. Carson?
Good morning. May it please the court. Sonia Carson for the United States. Chief Judge Srinivasan, Judge Rao, our understanding of the case is the same as I think the colloquy with both counsel before me have suggested. We think that the question before the court first is whether or not the jurisdiction stripping provision of the Sudan Claims Resolution Act is constitutional. I understand the plaintiff's argument under rational basis review, their version of rational basis review, to be that because Congress said in the statute that civil claims are an important means of deterring terrorism, that Congress cannot exclude from the restored sovereign immunity the claims of the 9/11 plaintiffs without unjustly disadvantaging or singling out these plaintiffs. And there are a number of problems with that argument. The first one, of course, is that rational basis review is not APA review. We do not hold up the text of a government action and ask whether the government has articulated, reasons that could support the best understanding or the most perfect implementation of those objectives. We ask whether or not there is any conceivable basis to conclude that the decision reflects rational policy rather than arbitrary action. And here there are any number of distinctions between these plaintiffs and the plaintiffs who were injured in the 9/11 attacks.
And it seems that the government's position is that is a more straightforward ground than the political question doctrine.
Yes. Yes, Your Honor, that's correct.
Can you say a little bit more about that?
So by deciding the distinct constitutional question, whether or not this court lacks jurisdiction because Sudan's sovereign immunity has been validly restored, we are applying ordinary judicially administrable principles of constitutional interpretation under the Equal Protection Clause. And here, of course, the plaintiffs have not been singled out. It's not simply the marks who are excluded from continuing to pursue their claims against Sudan in U.S. federal courts. It's anyone with any claim against Sudan, filed or not, that preceded the restoration of Sudan's sovereign immunity.
Could you lower the mics just a little bit, or lower the podium? Just have a little bit of trouble picking up your voice. Thanks.
I apologize.
Thank you. That's much better. Can I ask as a follow-up to that? As I understand your brief, you're actually not taking a position on whether there is a non-justiciable political question here.
So I think it's implicit from our brief that in requesting affirmance on the jurisdictional basis, we think that that question does not present a justiciability issue under the political question doctrine. And here, remember...
So you think that there's, you don't think there is a political question bar?
On these plaintiffs' particular claims in the context of this case, correct, we do not think that the political question bars this court from affirming the district court's judgment that there is no jurisdiction here because Congress validly reinstated Sudan's sovereign immunity and that the carve-out for the 9/11 plaintiffs does not pose any constitutional impediment to that action.
And there's no political question bar to us looking at that issue?
In this case, on the basis of the claims the plaintiffs have brought, no, there is no bar. Of course, our brief goes on to explain that if the case were to go further, if the court's analysis were to go further than affirming on the jurisdictional dismissal, then we do potentially get into quite complex and difficult political questions. However, as I think the colloquy between the counsel who have been at the podium before me has, I think, showed, there's no need for this court to go so far. In this case, what we have is a very straightforward, delineation between plaintiffs who filed their claims on the eve of the government action that's challenged here versus claimants who have been in court, some for more than a decade. We have plaintiffs who were injured abroad versus plaintiffs who were injured on U.S. soil. These are all the sort of entirely rational bases on which Congress can choose to make distinctions in the course of deciding whether a foreign state should rejoin the nations of the rest of the world, except for those designated as state sponsors of terrorism who are immune from suit in U.S. courts. Thank you.
Thank you, counsel. Mr. Perlin, we'll give you 2 minutes for rebuttal.
I address the investment of jurisdiction issue first. That seems to be where the court is focused. I think the Antelope decision, I don't have the citation handy. I think it's cited in Sudan's brief. That case demonstrates that there was a dissent by then Chief Judge Wald saying that if the case involves some racial distinction where those cases, the claims by a racial minority were espoused, that the settlement agreement would be, or the agreement would have been invalid. The majority decision said it's true that if there were a constitutional flaw in the resolution of those claims, we would be very concerned. Sorry, let me back up. Then the jurisdiction of the court was stripped. Claims were, jurisdiction of the court to bring certain claims was stripped, and the plaintiffs challenged that. They were non-Americans, and the court, both the dissent made the argument, and the court acknowledged that constitutional challenges to jurisdiction stripping must be heard, and they require the court's attention. I don't remember the exact language, but that was both in the dissent and in the majority opinion. Let me just say this. I agree with Mr. Kiran that equal protection is embedded in the challenge to jurisdiction stripping, and that compels a heightened scrutiny because when a constitutional right is deprived, the level of scrutiny is heightened. It's no longer a normal rational basis review.
And is that constitutional right, in your view, the access to courts?
It's several things. Access to courts, and it's also being treated similarly. It's being treated similarly to the other American claimants under the settlement agreement. That's the equal protection claim. There are several manifestations of the disparate treatment, and the access to courts is only one of them. But again, there's never been a settlement where some plaintiffs were American claimants were paid, compensated, received benefits, and others received nothing. The one last point I want to make is that neither Sudan nor the government has addressed the private settlement agreements. And now they're stressing the other bases offered to justify the distinction. If those bases really held water, it wouldn't have had to make up, to hide the private settlement agreements, which were not private. It wouldn't have had to deny falsely that the government was involved in those private settlement agreements. And so I think that throws into question every rationale offered for the disparate treatment.
Thank you, counsel. Thank you to all counsel. We'll take this case under submission.
Case number 22-7082, Broidy Capital Management LLC and Elliot Broidy versus Nicolas D. Muzin et al., State of Qatar, appellant. Mr. Science for the appellant, Mr. Tatar, amicus curiae, Mr. Saunders for the appellees, jurisdiction issues, Mr. Benson for the appellees, Vienna Convention issues.
Good morning, counsel. Mr. Science, please proceed when you're ready.
Thank you, Your Honor. May it please the court. The district court made two important errors that harm Qatar's rights and interests as a sovereign. First, The court held that the Vienna Convention on Diplomatic Relations is categorically inapplicable to documents, archives, and correspondence whenever they are freely given to a non-mission party. Second, the court held that principles of international comity are also categorically inapplicable when discovery is sought from a private party that is a U.S. national. This court should reverse both rulings and remand with appropriate guidance for the district court to conduct a document-by-document assessment. In doing so, the court should reject two arguments that have been advanced to limit Qatar's protections. First,
if we did agree with you that the Vienna Convention is not categorically off the table and we were to remand, how do we articulate the standards that the district court should apply? Since we don't have the documents before us, we don't have any sense of what type of issues are going to arise in that document-by-document consideration.
Sure, Your Honor. I think it's unfortunate that frankly, Qatar's request to develop this in a concrete way with a log is not where we are, but we are where we are. And we do think it is in the interest of the sovereign, of the parties to this case, of the district court, to at least get into some of these issues. So, for example, we know that there is this issue of FARA, there is this issue that's been raised about the contract. We know that there will be issues about the standard for documents that are generated by the contractors that incorporate.
Is it your view it's sufficient for us just simply to reverse and not provide guidance, or?
Your Honor, I think that in our view, the district court was wrong as a matter of law, and the court should reverse and hold that the categorical rule it adopted was incorrect, and the process needs to start. Obviously, the documents aren't here. The documents, there has been no log. So we think there's going to be a lot of work to do in the district court. Our request would be that it would be in the interest of all parties and the district court if the court did go a step beyond reversing that categorical
and what does that look like, I guess, is my question.
Sure, Your Honor. So I think we would start, with a point of agreement with the United States about, what documents of the mission means that are entitled to inviolability. We have offered certain factors. I think those are really, in our view, more granular ways of getting at some of the things that the United States government was talking about in terms of a special relationship, looking to was the purpose of the engagement and of the work that the contractors were doing related to the mission's performance of its functions. Was there an expectation of confidentiality? Was the mission exercising control in the treatments of those documents and information? So I think that is the first step. That's the standard that we would suggest. And then I think there are these sort of secondary issues that have risen. So to take one, this argument that Mr. Broidy makes, the United States does not endorse this argument, but this idea that because of this existence out there of a possible FARA inspection right, that means that the expectation of confidentiality vanishes. If that were accepted on remand, I think that would maybe entirely or pretty close to entirely end this. We think that is something that the court should also address as well.
That seems to me to be a very tricky question, because it seems, at least from the briefing and the records, that the application of FARA is, it's often worked out between DOJ and, diplomatic missions. And so our stepping into that with some type of standard seems like a difficult place for this court to be without more knowledge of whether FARA will even come up with respect to the particular documents at issue. But you're saying that we should address that question. And that seems to me to be a very tough question.
Your Honor, I think there's two aspects of that question, one of which I agree is very difficult, and we do not urge the court to decide, even though it's raised by Mr. Broidy's arguments, and the other, which I think is a much less fraught path. Our view is that probably the better practice is not to get into this question of if you had a clash between sovereigns, where the United States Department of Justice said, we want to inspect these records of a contractor of the mission, and then the sovereign representing that mission came in and said, no, some of these records are documents of the mission and they're inviolable under the Vienna Conventions. We think that is a legitimately hard, difficult problem. I completely agree, Judge Rao, with your point that this tends to be worked out between sovereigns. And I think unless and until two sovereigns can't work that out, that is an issue better left for another day. our view on how this issue should be resolved is to say, let's assume, for the sake of argument, that DOJ does have these inspection rights. That does not mean that the expectation of confidentiality that the mission has in the documents held by the contractor completely vanished. So we have this, possibility that maybe DOJ will exercise inspection rights, and maybe the sovereign will or won't object. Maybe that will be worked out some other way. But we think that that doesn't change the fact that in this civil case, there is still a reasonable expectation of confidentiality that when the mission shares with its contractors for the purposes of assisting it in its diplomatic missions, that's not. The United States gives the example of stuff getting posted on the internet. That's not anything close to what we're talking about with this hypothetical possibility of a DOJ inspection. So that's the path we'd suggest the court would go down. It does leave for another day.
I don't. But
I'm interested in a whole nother path going down. Perhaps it's the old district court judge in me. But I'm want to ask you some questions about the motion to dismiss this appeal. Do you think, as a general matter, that it should be easier for a non-party to get interlocutory review than a party in a civil case?
Your Honor, one of the two grounds for interlocutory review here is the Perlman Doctrine. And so under that doctrine, under this court's precedent applying for it, I think there are cases where an appeal would be available to a non-party but not to a party. I don't think the court needs to get into that because regardless of who is appealing, I think under the collateral order doctrine, this is appealable. But I think the concept of the Perlman Doctrine is that there could be cases where if you were a party, you would essentially have to go the contempt route if you wanted to appeal, but a non-party may have a separate basis to appeal.
Well, when has the collateral order doctrine been used with respect to a non-party? Can you cite a case?
Your Honor, I think this court's sealed case did rely on the collateral order doctrine. Now, I think Mohawk may have undermined the particular collateral order holding in Mohawk, but that was a case. You're just zooming out as a conceptual matter where a non-party to the case filed a notice of appeal, and this court entertained that appeal both under collateral order and Perlman grounds.
So I've looked at a bunch of our cases and the Supreme Court cases invoking either the collateral order doctrine or the Perlman Doctrine, and I can't find a single one where the appellant wasn't at least a movement of some sort in the district court, where they filed either a motion to quash, where they filed a formal objection, where they sought some sort of relief, and then they were appealing the denial of the specific relief that they sought. You didn't do that here.
Your Honor, I think we did. This case is complicated because Qatar is a foreign sovereign and because it was essentially facing the threat that if it intervened, the serious concern that Mr. Broidy would contend that was a waiver.
Who cares what he would contend? I mean, we have held since at least 1980 in the US v. AT&T case that a non-party can intervene for the limited purpose in a civil case to assert a privilege in a discovery dispute. And there's nothing in the text of 1605A1 or 1607 that suggests that limited intervention is going to waive sovereign immunity to be able to assert some sort of claims against Qatar. And the fact of the matter is that you could have sought such limited intervention consistent with our practice and what the Supreme Court says is the preferred way of proceeding. And then if your limited intervention had been denied you, then you could seek interlocutory appeal of that denial along with consideration of the merits of the dispute. And we wouldn't have this situation where we don't know what you are. You fish or fowl, we don't know. You're an amicus. You can't preserve arguments as an amicus below. We even have a rule where if you're a party and you don't join in a motion or an objection below, you can't assert it on appeal if you didn't join it. And that's if you're a party. So this is all a mess because you didn't pursue the option that was available to you to pursue. And I have a problem with that.
Your Honor, a couple of responses to that. One, I do think when a sovereign is involved, it is something fraught. I agree with you that it would not, in fact, have been an implied waiver or triggered the counterclaim exception. I think a foreign sovereign has a legitimate, reasonable interest in not even being subject to that risk, not even being subject to having to defend that claim. We know the district court suggested that it viewed that as a complex question. We could have wound up, with expensive proceedings, both in the district court and the Court of Appeal. So I think that's just a factual response to the unique circumstances here. On the broader question of whether you need to be, intervene or need to be a movement in the district court, I think that's not what happened in this court sealed case. It's not what happened in the Supreme Court's case in Devlin versus Scardelletti. The Supreme Court engaged in
But there, the party was going to be bound by the order. Here, Qatar isn't bound by the discovery order.
And it's not bound in the sense that it's not directed at Qatar, but it is losing an immunity and inviolability that Qatar claims.
If bound went that far, then someone who had an attorney-client privilege or work product privilege that they were concerned about losing would be bound by a discovery order. And that's not the way that bound has a term of art that has a particular meaning. It means that the judgment binds you for contempt or other enforcement purposes, or perhaps for res judicata or collateral estoppel issue preclusive purposes. And this doesn't do that. So you're not bound, so you don't fall within Devlin.
Sure, Your Honor. I think this court in the sealed case referred to being bound or otherwise having interests affected and undermined. That's certainly what's happening. I think you're certainly. I'm not saying that Devlin is factually on all fours, but I do think Devlin stands for is the court says, first of all, this is not a question of Article 3 jurisdiction. That's satisfied by the personal stake. It's not even an assessment of prudential standing. It's essentially a prudential rule about who has a right to an appeal. In the court's analysis where it said there that intervention was not required for the absent class members, it is a very functional analysis. And that's why I think it is appropriate to look to these questions of whether a foreign sovereign should be put into this position. The only other thing I would say is, Your Honor.
Well, it's practical. Also, you can say it's practical analysis on appeal. It's practical in the district court, whether or not you formally intervene or not, at least for this limited purpose, so that you can preserve arguments so that it's clear, like what arguments you're making and what arguments we can hear on appeal, what record you want to make, what you want to put in the record, what specific procedure you want, so that we don't have a situation where we're trying to figure out on appeal, is this something that the defendant asserted and did they make argument X, but you as an amicus made argument X prime? The defendant doesn't appeal, but you do. This is all of that could be solved if you had done what was available to you to do, and which would provide no risk to you to do. Because if you seek limited intervention and it's you're not allowed to intervene on the limited terms and conditions that you set forth, then you can challenge that.
Your Honor, I'd respectfully push back on the no risk proposition there. I think that in deciding in the state of Qatar deciding how best to assert its interests here, we did look for guidance on this, found this to be an uncertain playing field. I think going forward, if this court were to adopt a rule that said foreign sovereign that finds itself in this position should intervene, doing so will not be construed as any kind of waiver of sovereign immunity. And if you don't do that, you're out of luck. I think that would be a perfectly reasonable and acceptable rule going forward. I think as applied to this case, the FSIA provides an exception for sovereign immunity to waivers that are implied. The district court, in this case, at least thought it was a complex question whether this would constitute a waiver of sovereign immunity. And we had no Court of Appeals authority, any other authority to be able to say, to a sovereign, you are not at any risk here by showing up and intervening for purposes of this discovery dispute. Certainly, we might have said we think we would ultimately prevail there, but I really don't think it's no risk. So I think
it's no risk in the sense that the way that I understand intervenor practice, and you can tell me if I'm wrong about this and direct me to a case, but when a party seeks limited intervention, like I've seen cases involving Indian tribes, et cetera, that in the United States that have sovereign immunity, they can say, look, we want to intervene on this limited basis under these conditions where we are preserving our and not waiving our immunity as to A, B, and C. We're only intervening on this limited basis. And if the district court agrees that that's appropriate after hearing from the parties, then it grants that. And if it disagrees and says, no, I think that if you intervene, you're going to waive this particular immunity that you don't want to waive. That doesn't mean that you are forced in under those conditions. You can challenge that in the Court of Appeals. And if the Court of Appeals finds that that's an abuse of discretion, then you can intervene on those terms. And if it disagrees and you don't want to intervene on those terms, then maybe we have a question as to whether or not you should be able to pursue this as something other than a party.
All right. I think, in terms of foreign sovereign immunity, I'm just not aware of cases addressing this question. I think the analysis wouldn't necessarily be the same in the way it works in tribal sovereign immunity, only because we're talking about a specific statute that has a specific implied waiver exception for sovereign immunity. So I do think that there was risk there, and this was a reasonable path under the circumstances, and that this question of who is entitled to appeal as a non-party is functional and equitable. As Devlin says, I would suggest the cases that this court cites in its footnote in the Sealed case. When you look at how other circuits address this, it's quite an amorphous set of considerations that go to what's equitable, what's fair in the circumstances for whether a non-party is able to appeal. The last thing I would say on this is there is the possibility of construing this as a mandamus petition. The United States agrees with us that there was a clear error here and an entitlement to remand, and that I think is another option that may avoid some of these problems.
The concern I have, reason why I think we got to go to first principles here is Mohawk. I mean, Mohawk seems to say that you got to pick one door. You got to either pick the interlocutory appeal door under the collateral order doctrine, or you pick mandamus. Because one of the rationales of Mohawk's holding is that, look, as a categorical matter, attorney-client privilege claims, we're going to say are not subject to this collateral order interlocutory appeal doctrine, because there's a couple of things that you could do. You could perhaps suffer contempt, get direct appeal that way. You could ask for the order to be certified for interlocutory appeal. And if it's a novel question, then that's generally going to happen and you get interlocutory appeal that way. Or if neither of those are really going to be available to you, then mandamus will be available to you. And so you don't go through this door. So I think we have to figure out as a doctrinal matter which door must you have to go through, and if it's the petition for mandamus door, the reason that door would be available to you is because there's no other adequate relief that's available. So we have to, make a decision as to whether in these cases in general, that's the way that they're going to be handled. Not just we're handling it that way in this case because you didn't seek intervenor status. I think if you could have and were supposed to have sought intervenor status to deal with this, then the mandamus option shouldn't be available to you because you would you should exhaust these other possibilities as seeking collateral review under a party.
Sure. I understand, Your Honor, and I think actually this court's decision in the prior Broidy versus Muzin appeal is actually a good example of how the court has addressed something, for purposes of this case, but also going beyond. And what it said there was that case was entitled to a collateral order review, but because of what the court clarified in that decision, other cases might not actually rise to the level. Here, I think the court could quite reasonably say, going forward, if a foreign sovereign is in this position, it should intervene, and doing so will not constitute any possibility of a waiver of sovereign immunity. And if a sovereign is on notice of that going forward and tries to do it another way, then I think that would be a perfectly sensible rule going forward. I think, in terms of, the solicitude owed to a foreign sovereign, as the Supreme Court has said, seeking to have its interests heard in U.S. courts, there just wasn't guidance for what to do in this circumstance. We think that this was a reasonable way for the state of Qatar, faced with these risks, faced with these concerns, to proceed.
Can I ask one follow-up question to colloquy earlier? So can you just state concisely what you think we should say about the FARA issue?
Your Honor, I think that the court does not have to
If we get to it.
Sure. If you get to the FARA issue, I think the court can say it is a hard question. What would happen if DOJ was seeking to inspect records that a foreign sovereign claimed were inviolable documents of the mission? I think in this case, the court can say that in this civil discovery dispute, the hypothetical possibility the DOJ may in the future seek to inspect these records does not so undermine the expectation of confidentiality in those mission records, in those mission documents, that they cease to become documents of the mission under the standards that the United States and Qatar.
And why would we even say that? Why not just leave it all open to be worked out on remand, the way that the FARA intersects with inviolability principles, and then we can always consider it in a subsequent appeal if necessary?
Your Honor, I certainly don't disagree that that's a path that's open to you. Mr. Broidy has raised objections to the possibility of this.
In other words, you don't view the state of things in the district court to be such that if we get to that stage and if we were to send it back, that the issue of the way that the FARA intersects with inviolability is already a foregone conclusion in the district court.
Your Honor, there is a I believe a paragraph or so of the district court's opinion that does address that. It is sort of confirmatory, as I read the opinion, it's sort of confirmatory of the district court's broader textual view
other conclusions. But by hypothesis, we would have already, if we even get to that stage, then the premise would be gone.
Correct. So, yeah, I think it would be open. I think we're here as a non-party wanting to be heard, and if that means having this fleshed out in the district court with the possibility of coming back if it results in another categorical ruling that we think is wrong, I think that's okay with us. I think from the parties may have views about that. And we're not trying to be.
No, but the way you read the state of things in the district court is that it would all be open.
And I think by hypothesis, if the court rejected the district court's overall framework, adopted another one, perhaps one similar to the United States and Cutter's, I do think it would be open. My view personally is that it would be useful, but certainly, I think we could make that argument.
I have another question about Mohawk. Mohawk, the Supreme Court said, we're not going to look at like creating whether this sort of discovery dispute involving attorney-client privilege kind of falls within the third prong by looking at the facts and circumstances of any particular case. We're just going to make a categorical ruling that attorney-client privilege challenges don't meet this third prong of the Cohen standard, right? And they said we're going to do that by looking at how much deferring review or the inapplicability of review, would thaw and harm people who would seek to benefit from the privilege. And the court acknowledged that, part of the argument here is that this type of privileged information should never be disclosed. But the court reaches a conclusion that, notwithstanding all of that, we don't think that this is going to essentially have some sort of serious negative deleterious effect on people's ability to consult with their attorneys. Don't we have to, for you to prevail and for us to agree to hear this appeal, don't we have to kind of reach a conclusion contrary to Mohawk's analysis of attorney-client privilege for this particular privilege that you are asserting?
All right, I agree that the analysis is categorical. So on the question of the collateral order doctrine, the question is not, is Cutter's specific claim here and the facts of this case, effectively unreviewable? The question, I think, I would phrase it as, an objection to disclosure and discovery on the basis that something would violate the Vienna Convention on Diplomatic Relations. That's the category. So I think you would go through the Mohawk analysis, and the court gave a number of reasons why, for attorney-client privilege, an appeal at the end after a final judgment was enough. And what the court said is, as important as the attorney-client privilege rule, the rules of the road are known. This is well settled. Not much is going to be gained by all these appeals. There's going to be a lot that's lost by having all those appeals in the courts of appeals burdened with that. I think, as the United States brief confirms here, what's at issue here is the question of the United States compliance with its obligations under an international treaty. As important as the attorney-client privilege is, that's something of a different order. It's not something, as the court emphasized in Mohawk, where there is sort of a well-trod analysis that the Court of Appeals have developed, so there's not much of a chance of reversal on appeal. These are complex and novel issues. So, I think, we have no problem with following the analysis of Mohawk. We just think it comes out in a different way here, just as, this has never reached the Supreme Court. This court routinely holds that a denial of sovereign immunity because of the particular harms involved of forcing a sovereign who may be immune from facing the burdens of suit, that this court routinely says that qualifies under the collateral order doctrine. I think when you have the category here of a claim of inviolability under the Vienna Convention on Diplomatic Relations and the possibility that the United States will instantaneously be put in violation of its international law obligations the moment of disclosure, and that is a particularly important interest that's at peril and that justifies review under the Mohawk standard.
Thank you, counsel.
Thank you, Your Honor.
We'll hear from the government now. Mr. Tataro.
Thank you, Your Honors. Martin Totaro for the United States. If I could just briefly address the jurisdictional piece before moving to the merits. I think unlike evidentiary privileges that can be protected through an appeal with a remedy, if the defendants turn over inviolable documents, Qattar's treaty rights will have been violated at that very moment. And so that's a value of a high order, not only because we're talking about Qattar's treaty rights, but we're also talking about the United States obligation to safeguard those very rights. So I think in that circumstance, coupled with all the other distinctions with Mohawk Industries we discussed in the brief, just a very different case. And then the final brief point I'll make is that this court, the first time this case was up on appeal, took a practical, pragmatic approach to appellate jurisdiction, and we think it should do so again here in the same way that it does when we're talking about an issue of foreign sovereign immunity, where we're talking about a violation where the harm occurs at the time of the violation that cannot be remedied on appeal.
Can I ask you, do reciprocity considerations come into play even with respect to jurisdiction? So, for example, I could understand that the United States would be concerned that if it were in a similar situation in a foreign jurisdiction, it would also want the ability to get its inviolability assertion heard as soon as possible before the documents would be disclosed.
100% correct. Yes, we agree with that.
And should that be done by mandamus, or should that under the mandamus standard, which is different because you have to show kind of a clear right to relief, clear and indisputable, versus a non-party being able to avail itself of the lesser standard of collateral order review?
Judge Wilkins, I think in this specific case, the government is agnostic, because whether it be through the collateral order doctrine and the lack of an effective remedy on appeal, or through mandamus, the district court's categorical approach, which we think was clearly in error, that could be resolved through mandamus as well. So I understand, I take your point that in many cases, party, you're going to have to generally choose collateral order or mandamus. Here, I think regardless of which path the court chooses, all of the requirements are satisfied. So it doesn't really matter to the United States how appellate jurisdiction is established, just that the fact that it is established. So as Chief Judge Srinivasan pointed out, the foreign sovereign's treaty rights can be safeguarded.
Just so that I'm clear about the United States' position, what do you think is the clear error, the Vienna Convention's analysis, or the International Comedy analysis, or both?
The clear error, Your Honor, and this can also lead me into the merits, is the adoption of a categorical rule that whenever documents are freely given to third parties, those documents necessarily fall outside the Vienna Convention. And I'm happy to talk about why that's irreconcilable with the text purpose.
Because you didn't even talk about international comedy in your brief, right? Your entire brief was about.
Yes, Your Honor, sorry to interrupt. This court's order asked us to focus on jurisdiction and the treaties, and so the United States did so. And so the United States hasn't offered an opinion on international comedy in this case, in this context. And so, on this.
Oh, sorry.
So I will address the text of the treaty, the purpose, practice, but at the outset, I wanted to be upfront that one critical concern to the United States is that the district court's categorical error poses a serious threat to how the United States operates its embassies overseas from terms of reciprocity. So the United States, as a matter, I don't know if routinely is the proper word, but it not infrequently uses outside contractors to carry out essential functions as defined under Article 3 of the Vienna Convention. This is most often seen in terms of like embassy construction or security personnel. And as the government reads the district court's order, none of the very important documents that are provided to those individuals, including for example, like blueprints of an embassy, would be protected by Article 24. And that, as a matter of reciprocity, is a very serious error, and it cannot be reconciled with the text of Article 24, which is talking about the protection of documents wherever they may be.
Can you also speak to the question about the intersection between the Vienna Convention and FARA? Because obviously DOJ is the entity that enforces FARA. I mean, do we need to say anything about that in this case? And do we need to? Should we? And what would that look like?
So I do not push back against the hypothetical or the question lightly, but I think the court should be very careful about what it says about the potential intersection between the FARA and the Vienna Convention, because doing so could raise significant domestic and international concerns. There is no need for this court to address whether there is a potential conflict between the FARA and the treaty. And one potential way to avoid that issue would be through the framework we've adopted, which is to say, look, the text of the treaty does not resolve when documents given to third parties are, quote, of the mission, even though those documents would be subject to FARA inspection. The critical inquiry instead, as we know from international scholars like Denza, is whether the entity had a reasonable expectation of confidentiality when it handed those documents over to a third party. And on that question, our brief provides a framework where we set forth three factors that all point toward that overarching question of confidentiality. And then to get directly to your point, as applied in this case, we have the text of the contracts between the mission and the particular consultants. That, in the United States view, allows this court to sidestep the direct issue of whether the FARA ever poses a conflict with Article.
Well, suppose we disagree with that. Suppose we don't think that the boilerplate about as required by law, that's what you're talking about, right?
Yes, sir.
Suppose that we don't think that that resolves this issue. Then, I mean, I know your argument is that as required by law, FARA is a law, and therefore the contract already presupposes that documents can be turned over under FARA. But suppose we think that there's something to the other side's notion, which is, well, that's just circular because the whole question is whether it's required by law. Then where are we with respect to FARA? And then where does the United States think we should go in an opinion if all the other predicate steps get us to that point?
So on the premise of the question, just to be clear, under Cutter's view, as required by law has no meaning whatsoever in the contract, boilerplate or not, because under Cutter's view, this is in footnote 11 of the brief, that only applies to documents that aren't of the mission anyway, and so that phrase need not be in there at all. And so those contracts could have very easily said, for example, consultant, while you may, under the laws of the United States, give those documents to the Department of Justice if inspected, under no circumstances can you give these documents to others in private litigation. But Cutter chose not to do that. And so our point is merely that when you hand over documents to a third party against the backdrop of FARA, that diminishes but does not eliminate the expectation of confidentiality. And to get to the point,
suppose I take that point, but suppose we just don't think it's that's definitive with respect to FARA.
Right, and so I think the problem there is that a document either is of the mission or it's not of the mission. And so a document can't be of the mission if it's requested not of the mission if it's requested by the United States, while at the same time being of the mission when requested by a private party in litigation. So our point was merely that once you undermine that confidentiality expectation, it takes it out of the realm of being a document of the mission. But I take the point that I don't want to fight gravity here. And if the court disagrees with that, one option, which I think Cutter laid out on page 22 of its reply, is to say, look, these documents might still be of the mission, but the contracts consented or waived any request by the United States, by the Department of Justice, when we're in the land of FARA. So in that circumstance, the documents could potentially still be of the mission, but the court would need not have to address any potential conflict between FARA and the treaty, because it would say, regardless of whether those documents are of the mission, even if those documents are of the mission, the government, the Qatari mission has consented to them being turned over by the United States.
So if we were to remand and the district court concluded that a particular document was of the mission and therefore inviolable, is it the government's view that they could still seek that document under FARA?
So then
like if there had been a ruling by district court that it was inviolable in private litigation?
I think so, Your Honor, because it wouldn't address this issue of consent or waiver. And so it would be, the district court would say, look, this seems like a very important document that satisfies the framework of confidentiality.
And then it's just a separate question.
And then it's a separate question. And I think it would be important if the court went that route to make clear that it is a separate question when we're not talking about private party litigation, but when we're talking about the United States invoking its inspection rights under the statute. The reason why this hasn't popped up, I suspect, is because, as Your Honor noted, this tends to be done on a sovereign-to-sovereign basis, as opposed to this rather unique situation. And so,
but then the result would be, though, and there is something intuitively, at least, possible about this result, is that inviolability prevents the document from being turned over in this kind of litigation, but it doesn't prevent the government from obtaining the document pursuant to FARA.
And I think that would be because of some sort of consent that Qatar.
So you think you'd have to point to something in a contract itself in order to reach that result. But for that, there's no way to reach that result?
I think the contract is the easiest way to duck the potential very thorny issue of whether, if a document on a remand is of the mission, whether the United States can invoke its statutory inspection rights without being in tension with Article 24. But again, I cannot stress enough that I don't think the court needs to reach that direct issue. I think rather the more appropriate course is to say, district court, the categorical approach you adopted is incorrect. Here are the proper factors. And then focusing on the language of the contract, either agreeing with the United States position that this has significantly undercut or diminished the expectation of confidentiality, therefore probably taking those documents outside of mission status under 24, or the route Qatar has proposed, which is to say, look, the documents at a minimum consent to inspection by the government, but that's a separate question entirely from whether in private party litigation they're subject to discovery.
Or just leave that all.
I'm sorry?
Or just leave that all to be worked out on remand. I don't even know that, why would we even have to do either of those two? Why would we not just send it back and say?
It is certainly within the court's discretion not to do that. I think this is a situation where more guidance might be better than less, just to provide the proper signposts so we're not here.
If we thought we had enough information with which to give signposts and.
Yes, Your Honor.
Yeah.
Just ask you as a factual matter, does DOJ litigate under FARA against foreign sovereigns? I'm assuming not very often, but I was just wondering as a factual matter if those such cases are.
Unfortunately, I'm by no means FARA or criminal expert. I know these issues pop up. I think I don't know how many inspections there are a year. I think it's something like 20 inspections, and I just don't know how often it gets litigated where. Well, I don't think it gets litigated, but I don't know how often a foreign sovereign comes in and says, wait a minute here, we're dealing with very sensitive ground. And I
was just curious.
And I think the lack of cases speaks volumes about, to the extent it's ever addressed, how it's addressed at a more diplomatic level.
Can I ask you, the government didn't reference Article 27 in its brief, I think?
We did not.
And is there a reason for that?
We're not sure that Article 27.2 gives anything more that Article 24 otherwise wouldn't provide. And it seems like the clear thrust of Article 27 is talking about correspondence between the sending state and the embassy itself. I don't want to sort of put forth a categorical position that the United States view that that's where the only circumstance in which Article 27 applies. But here, as I think the scholar I noted before, Denza, said it best, it seems that Article 27's protections are duplicative. So I just don't think it does.
It doesn't add anything.
I don't think it does any work that Article 24 doesn't already provide. Just like I'm not sure that the Perlman Doctrine on jurisdiction would do any more work that the collateral order doctrine or the mandamus.
And you don't think if Article 27 is narrower, that then that narrowness gets read back into Article 24?
Right. No, I don't think Article 27 takes away anything provided.
One last fair question. What triggers the inspection power or rights of the government? Is it just because they want to, or do they have to have some sort of cause or justification? Do they have to seek leave of court? What enables the government to inspect the records that are required to be kept under FAIR?
Well, I'm not exactly sure what triggers the exception right, except I know you are subject to the regulations that get triggered when you have to register as an agent under the foreign agent registration. So I'm not sure if there, and I apologize, if there's not a second further step. I would be surprised if there were. The critical question, I think, is that question in the first instance of whether you need to register. And all of these
so we don't know whether you have to get a warrant or whether the FBI can just show up and say, you're registered under FARA. There's all these records you're required to keep. We're here to see them, hand them over.
It's my understanding, as a matter of practice, this isn't something where federal agents are banging down your door. It's a collaborative process where there's an inspection that occurs, I think, either on premises or even through a server or whatever, where the documents are put, and then the government can look at the documents.
So at least you don't have any reason to believe that a warrant or subpoena or some sort of court authorization is required for that inspection to occur.
I could be very wrong, but I don't think so. So you're on.
I have one other question about, and this goes back to international comedy. So I know you didn't address it in your briefing, you didn't have to, but you could have, and because I don't think the order cabin the grounds is pointed to particular grounds as a possibility. And I'm just wondering, do you have a view on that on behalf of the United States? Does the United States think that comedy adds anything when you've got something specific that deals with the terrain like Article 24 does?
So the United States did not opine on that question, but the United States does not want the court to read into anything. Like it's not that the government thinks that comedy plays no role here or can play a role on remand. We just have taken no position, and instead we, focused on the text of the court's order in a rather compressed.
And what is? I know you didn't do it in your brief, but are you prepared to say anything about the government's view about comedy in the abstract here, or the role that comedy may or may not have vis-a-vis the particular provisions in the conventions?
No, Your Honor. We think this case can be resolved. This appeal can be resolved purely on the court's interpretation of Article 24.
But I don't know about that, because if under the conventions, what the government wants is for us to remand and to have a document by document run through to see if the factors are satisfied with respect to each document, which is where I think you are.
Yes, sir.
Then there's at least conceptually a broader question, which is, would comedy come in and come across the board and say, you don't even have to do document to document? It's more wholesale than that.
I'm not sure I understand how it would be more wholesale by category by category. I think the factors we set forth in the brief could go a long way toward the type of document by document or category of document by category of document review Your Honor is suggesting on remand. But I'm not saying that comedy should be foreclosed on remand. The government is merely hasn't taken a position on the issue altogether, one way or the other.
And comedy would not get cutter any more than that, I assume, because otherwise then we do more than remand and just set out the factors, because there'd be the potential that there'd be a greater grounds for what we'll call inviolability pursuant to an overhanging comity doctrine.
I could imagine Qatar arguing something along the lines of apply the factors as set forth in the United States brief, but if there are close calls, then comity could play a role in the district court's decision of whether a document is in or out. And on that issue, again, we're not.
You don't have any view on
but
that.
I could imagine it playing a role.
All right.
Thank you. And thank you for giving us the opportunity to participate in oral argument.
Thank you, counsel. Mr. Saunders.
Your Honors, may it please the court, and I will be addressing the jurisdictional issues, turning it over to my partner, Mr. Benson, to address the issues regarding the conventions and comedy. So the two questions, separate questions that really need to be addressed at the outset, two separate hurdles that Qatar needs to overcome are, one, is the district court's discovery order granting the motion to compel appealable at this stage? And two, does the state of Qatar, a non-party who has not intervened, sought to intervene, have standing to appeal it? And unless both of those preliminary questions are answered affirmatively, you don't even need to reach any of the other issues that we've been discussing here today. Mr. Zients suggested essentially that this court should issue an advisory opinion regarding what would have happened if Qatar had sought to intervene for a limited purpose and what effect that would have had on its sovereign immunity. We're not looking at advisory opinions here, I submit. Let's look at where we are based on what has happened in the district court and where Qatar stands now. With respect to standing, we know that allowing non-parties to appeal even a final judgment is a rare exception to the general rule that only parties to a lawsuit or those that properly become parties can appeal an adverse judgment. Qatar talks about the in re sealed case decision from this court, specifically a footnote that talks about standing. It's actually dictum because the footnote itself makes clear that standing wasn't even challenged in that case. And of course, in re sealed case, which relied on this court's decision in U.S. versus Philip Morris, was itself overruled by Mohawk. So we're talking about their main authority for standing being dictum in a footnote in a since overruled case. That footnote states that if the decree affects a third party's interests, he is often allowed to appeal. And that was actually quoted language from the Fifth Circuit's decision in Castillo versus Cameron County, which was a case where a state that was itself a former party to the litigation was bound by an injunction that related to jail overcrowding and at risk being found in contempt if it violated that injunction. The only other cases that Qatar relies on for standing are similarly cases where, such as Devlin, where the non-party was an unnamed member of a certified class that was bound by a settlement, or the Karaha Bodas case from the Second Circuit, where the non-party was required to surrender property pursuant to an order of attachment.
Can I ask you, do you agree that if there would have been an intervention, that there would not have been a waiver of foreign sovereign immunity?
I agree with Judge Wilkins that there's clear precedent for intervening for a limited purpose. And that
do you agree that there's a way that Qatar could have intervened? You can call for a limited purpose, such that they would not have waived their sovereign immunity, but still would have been able to assert the arguments that they're making now?
You know, I think it's an open question that would have to be resolved based on the specific arguments that they made in connection with the intervention.
The more it's an open question, I mean, if you're not able to agree to that, then it seems difficult to reach the conclusion that they should have intervened and not worried about waiving foreign sovereign immunity.
Well, again, that would have been something that would have been addressed by the district court. And as Judge Wilkins pointed out, it could have been taken up to this court if the district court had denied it, and that could have been resolved. But they didn't even attempt to do any of that. So that never ended up coming before the district court or this court. But as Judge Wilkins pointed out, the language from Devlin that Qatar relies on talks about non-parties being able to appeal if they are bound by the order that they are seeking to appeal. So what does it mean to be bound by the order? Again, we have cases where non-parties were bound by an injunction, non-parties were bound by an order of attachment. Qatar isn't bound by anything, because the district court's order doesn't require it to do anything. Much more on point is this court's decision in Moten, which held that a party that had filed papers in the district court but had not sought to intervene and stood in the position of an amicus was not entitled to appeal, and that this court had no jurisdiction. That's exactly what we have here. Just like the non-party in Moten, Qatar never sought to intervene. The district court ruled in its minute order of December 8th, 2021, that Qatar would be allowed to submit statements of interest in the posture of an amicus, and Qatar did not appeal from that order, the order that said it only had amicus standing. It did not seek to intervene in response to that order. It accepted its limited role as an amicus curiae, and in fact, in its statement of interest that was submitted in connection with the motion to compel, Qatar stated, quote, pursuant to the court's order of December 8th, 2021, Qatar files this statement of interest as the equivalent of an amicus brief. That's a Joint Appendix 227. So when they accepted their status as an amicus, in doing so, they accepted the consequences of that status, which is they don't get to appeal.
Let me follow up on Chief Judge Srinivasan's question. Do you agree that if Qatar had filed a motion for intervention that says we want to intervene on the condition that we don't waive our sovereign immunity by this limited intervention, and if you, district court, are not willing to essentially rule that that will be the terms of our intervention, then we withdraw our request to intervene. So they make clear that, like, we are requesting to intervene only if we get a ruling from you that says that this will not result in a waiver, district court. Do you agree that they could have filed a motion to that effect?
I agree they could have filed a motion to intervene under specific conditions. And if that motion was denied, then that motion would itself, I believe, be appealed to this court.
And do you agree that they couldn't be kind of like forced to intervene on conditions other than what they requested?
I would agree. Either they intervene as requested in the motion, or if the district court finds that is not possible, they're not going to compel them to intervene if Qatar is not seeking to intervene. Qatar would not be seeking to intervene.
In other words, they can't be compelled to intervene and waive if they say we only want to intervene if we're not waiving.
I think that's correct, Your Honor. And if the court denies that, they can then make a decision. They can either accept that status, okay, we're not going to intervene, or we're going to intervene under the conditions that the district court allows, or we're going to take up the decision to the Court of Appeals.
And then if they do that, and the district court says in response, well, I don't know that you need to do that, because maybe we can just proceed so that you participate in the way that Qatar did, then your view would be that, no, Qatar shouldn't accept that because they can get an up or down on the motion so that they can make sure that they preserve their status as an intervener with the party able to appeal. And they could say, no, we need you to resolve our motion, and if you don't, we're going to take that up because we want to make sure that we get a definitive resolution on whether we can intervene so that we can protect ourselves from the counter argument that we should have intervened. That's what should have happened.
I think that's correct.
I see. That's quite intricate, but I take the point.
But again, we're talking about a hypothetical scenario that just doesn't apply here. We're looking at where we are today with a party that accepted its status as an amicus, did not seek to intervene, and is now seeking to claim standing under dictum in a footnote in an overruled case. I see I'm out of time. If with the court's indulgence, I'd like to say a few things about the collateral order document.
Yeah, if you could keep it brief, that would
That's
be
okay. I'll try to keep it very focused. So I agree, Judge Wilkins, you said you haven't found a case under either collateral order or Perlman where the appellant wasn't at least a movement in the district court. We're not aware of one either. Clearly, we know that under Mohawk, this is a discovery order. Discovery orders, including those rejecting claims of privilege, are not subject to the collateral order doctrine, even though the Supreme Court recognized there may be some collateral damage. There may be some harm that is only imperfectly reparable. Now, Qatar tries to distinguish Mohawk by saying that the privilege here is on an entirely different level from the attorney-client privilege. But I'd point the court to pages 22 and 23 of Qatar's reply, where Qatar expressly analogizes the claimed convention protections to a series of attorney-client privilege cases. And this court itself has recognized the attorney-client privilege as inviolable. The government talked about once the documents are turned over, the convention is violated at that very moment. But once attorney-client privilege documents are turned over, the privilege is violated at that very moment too. And yet under Mohawk, that itself is not enough to invoke the collateral order doctrine. And we'll submit on the Perlman doctrine, on the briefs. We don't have a disinterested third party here. I mean, everything in the record shows that. Mandamus, we don't have a clear abuse of discretion. We don't have a clear and indisputable right to relief. The district court relied on all available precedent in its reading of the conventions. And even should this court disagree, which we certainly don't think the court should, we think the district court's order was sound. It's not the type of rampant district court decision that is some type of usurpation of power as discussed in Mohawk that allows for mandamus. And the last point I'd make before turning it over is this. I quote from this court's own opinion in the first appeal in this case on the immunity issue. The court said, quote, immediate appealability is strong medicine that is harmful when misused. We are now in this case that was filed nearly 4 years ago. This is the second interlocutory appeal. Discovery has still not even begun in earnest. Defendants have produced virtually no documents. If this court were to find that Qatar has standing, that this is an appealable order, and further remand to the district court for a document-by-document review, I promise you, I don't need a crystal ball for this, we're going to be back here on document-by-document appeals. Because Qatar's interest here is delay. Judge Forrest in the Southern District of New York, when this same issue came up with defendant Allahan's documents, said at Joint Appendix 281 about Qatar's tactics, it just smells like gamesmanship. So every determination that the district court makes regarding production of particular documents, not just discovery directed to the defendants, but there are third-party subpoenas that are out to other prior registered agents. As to all of those, Qatar is going to appeal those, every determination of turning over documents as implicating its privileges and immunities, as implicating international comity. We will have piecemeal prejudgment appeals that will be subject to tremendous delay and abuse. It'll be 5 more years before anything happens in this case, clearly undermining efficient judicial administration and all of the other very real problems that the final judgment rule of Section 1291 was intended to alleviate. So with that, I'll turn it over to Mr. Benson. Thank you.
Thank you, Mr. Saunders. Mr. Benson.
Good morning. May it please the court, Daniel Benson for appellees. Fortunately, that parade of horribles does not need to and should not take place. There is the government and Qatar's position that the order, the decision below was categorical is not really true. The judge made clear that she wasn't ruling on, for example, bail or bailee situations or construction contractors or the like, that the order applies to these defendants with respect to these documents. And this court can confirm on that basis. It doesn't need to issue an affirmance saying, you know, if any document is turned over to a third party, it's no longer inviolable under the Vienna Conventions. It can do a more limited ruling. I'm not saying that, by the way, that is wrong. It may very well be right. There's a cogent and potentially correct argument that if a government turns over documents to a third party, then by definition, they're no longer inviolable. But here we have a situation where Qatar put documents that contained highly confidential trade secrets, according to Qatar, in the hands of public relations blacks and lobbyists, even though it knew that those documents would be subject to inspection at any time on reasonable notice by the U.S. government.
Isn't the district court's decision categorical as to, I mean, you agree that it's categorical as to these defendants?
Yes, it is categorical as to these
So
defendants.
how does that fit with the text of Article 24 of the Vienna Convention, which speaks of documents of the mission? It doesn't seem to speak to who holds them, but rather what the documents are.
Well, if the Vienna Convention was adopted after FARA had been in existence for probably 30
Well,
years.
just put aside FARA for a second. Just focus on the text of Article 24. I mean,
Professor Denza, whom the government and Qatar recognize as the leading expert, has opined to Congress and in her treatise. She's the leading expert, if not the only expert on the Vienna Conventions, and she's explained what that of the mission is. You know that these, in fact, before Congress, she testified, and I recommend reading her testimony, but in full. But she testified and opined that documents that a country, that Saudi Arabia gave to public relations consultants were not of the mission and were not protected under the Vienna Convention. If the Vienna Convention had meant to protect those kinds of documents, it would have said wherever they may be and whoever might be in possession of them, or even more to the point, wherever they may be and whoever may be in possession of them, even if those people who are in possession of them are subject to a host country disclosure requirement. It doesn't say that.
But it also doesn't say mission documents. It says documents of the mission, which suggests that they could be held by somebody other than the mission itself.
That is I think overbroad. And there was no intention to protect all documents of the mission. As Professor Dentz explains, it really meant documents that were in effect on the premises of the mission, or in diplomatic pouches, or the like.
So what's your view as to when of the mission stops? That once the documents leave the premises, they're no longer of the mission?
Well, if they go to third parties, I think there's a very strong argument that they're no longer inviolable and no longer of the mission.
Period. Whenever they're given to a third party.
We don't have to reach that issue.
And what's the narrower way to do it then?
Pardon me?
What's the narrower way that you say you don't have to reach? Because that ground means
if they're given to individuals in the host country who are subject to a disclosure requirement to the host country's government.
So that's the fair argument.
Yes.
So the broader argument would be once documents are given to a third party, they're no longer of the mission, period. The narrower argument would be once documents are given to a third party and there's something like FARA, they're no longer of the mission.
Correct. With the addition that the reason for the first argument is that the country's Qatar, in this case Qatar, is treating them as not inviolable by giving them to third parties.
So can I ask this? If Qatar invites a third party onto the embassy's premises and says, "You're my contractor. I need you to do some work. In order for you able to do the work, I need you to look at some documents. But I'm really concerned about these documents, so I'd like you to come on my premises and look at the documents. I'm going to put you in a separate room. Here's the documents." And the contractor looks at the documents and then leaves without the documents, but now knows what the documents say and can use that to the benefit of the contracting enterprise, whatever that may be. You don't think in that situation the documents cease to be subject to the inviolability?
That's correct.
And then if that's true, then does it make all the difference if the country then says, instead of having you come over here, here's what I'm going to do. I'm going to give you these documents, but here's all the conditions. It's exactly the same conditions that I would have imposed on you if you came onto my premises. I'm going to take them to you in an armored truck. My security guard is going to be standing right next to you while you look at the documents. I'm going to take them from you, and then I'm going to take them back. Is it no longer of the mission because they were allowed to leave the premises?
They're in the hands of couriers, in effect of couriers with protection like that, then I think there's an argument that they're still of the mission.
I see. Okay, so it's not a premises specific. It's
in the hands of couriers or in diplomatic pouches or on the premises of the embassy. But again, this court doesn't need to reach those kinds of issues. There's no question that even under the Cutter's framework, which is a made-up framework, but that, that it depends on the expectation of confidentiality. There's no way that a country could have an expectation of privacy when it turns over documents to FARA registered agents.
That might be why, why they lose on a document by document review, but it doesn't suggest why there should be a categorical.
If the documents are open to the inspection by the government at any time for 3 years after the end of the agency of the relationship, how can they have an expectation of privacy with respect to confidentiality with respect to any of those documents?
Can you just clarify what the document request that's at issue says? What does it request?
They're asked for categories of documents, communications between Qatar and the defendants, payments by Qatar to the defendants, a whole series of questions like that. And by the way, Qatar professes ignorance as to what these documents are. These documents are 3 categories: documents they sent to the defendants, documents they received from the defendants, and what they claim are documents between and among the defendants. They know what those documents are. They certainly know what the information is that they claim is so sensitive and inviolable. They could have made a showing to the district court.
But do we know that all of the documents that fall within the document requests would be subject to the record keeping and inspection requirements of FARA?
And I believe that the inspection requirements I think that a FARA registered agent is required to keep pretty much all documents. If you look at FARA, it's a very broad requirement, and they have to keep the documents open for inspection at any time.
So it's your position. I'm just trying to understand your position that every document that would be responsive to the document request would fall within FARA record keeping and inspection requirement.
Certainly the document, at a minimum, all the documents that Qatar professes to be now concerned about would be.
Okay.
So, Mr. Benson, wouldn't that require a quite broad ruling from us, though, to determine that any documents that were available potentially in the future to inspection by the U.S. government trumps any Article 24 protection that the documents might have?
It doesn't trump Article 24 protection. The Vienna Conventions provide, just like Qatar's contracts provide, that they're subject to the law. The Vienna Conventions in Article 41 say that the laws of the host country must be respected. So the countries who adopted the Vienna Convention, including Qatar, I believe in 1961, knew about FARA. They knew about, they obviously adopted Article 41, which said that they agreed to respect laws of the host country. So I don't think that there's an argument that, we're not arguing that FARA trumps the Vienna Convention. We're arguing that it's perfectly consistent with the Vienna Convention.
Well, but that to the extent something is covered by FARA, to the extent that a document is covered by FARA, that it cannot receive the protections of the Vienna Convention.
Not inviolable. It's no longer inviolable by the actions of the country itself.
I mean, the Department of Justice doesn't take that view. They are charged with enforcing both. The U.S. government is charged with enforcing both its treaty obligations and its statutory obligations, and they think that they are, in most instances, compatible.
I think that the government is wrong. I think they're plainly wrong. I think every authority that has addressed this issue has come down the way Professor Denza has come down, which is documents delivered to people subject to FARA are not inviolable under the Vienna Conventions.
Well, I think you kind of can't have it both ways. I mean, you say that inviolable under the Vienna Conventions is, is the same as the attorney-client privilege is considered to be inviolable. But there are limited exceptions where privileged documents might be able to be reviewed for some purposes but not disclosed for other purposes. And so why can't it be under the Vienna Conventions that it's still considered inviolable? Maybe under U.S. domestic law, there's some limited availability for the Justice Department to inspect documents for its compliance purposes, for its counter-espionage or national security purposes. But that doesn't mean that any, every Tom, Dick, and Harry that files a civil lawsuit can have access to the document.
There's no authority or support in the Vienna Conventions or in FARA or any other law that would support that. But even more importantly, what Qatar is arguing for and what the government is arguing for is an analysis of what the reasonable expectations of Qatar were. And attorney-client privilege is a longstanding doctrine that's asserted every day. This inviolability for FARA documents that are exposed to the public, that are available for inspection, every authority that's ruled on it has agreed with our position. And so when Qatar signed those contracts with their with these defendants, they knew that Congress said that those documents would be not inviolable. They knew that Professor Denza said that those documents would not be inviolable. They knew that the House of Lords had ruled that those documents given a broad array of third parties would not be inviolable. They knew they didn't have any reasonable expectation of confidentiality or of inviolability. They couldn't have. So under their own analysis, these documents are not inviolable.
Because of FARA.
Because of FARA. Because of all the authorities before they signed the contracts that agreed with that analysis.
About FARA.
About FARA.
Yeah. Can I just ask a basic factual question? Is it the case that every third party that contracts with a foreign sovereign has to register as I take it there's some contractors that don't have to be subject to FARA, or is that wrong?
I think that's correct. I think it's directed toward contractors that are, a lot of times people, I think, register out of an excessive caution, just, it's a criminal offense. But I don't believe that, for example, if a plumber who does work for Qatar would have to register. I think it's these kinds of activities, propaganda activities, and the purpose of FARA, of course, is to make sure that those clandestine activities are subject to exposure and subject to the government finding out about them.
So can I ask this question then? If it's true that not everybody who contracts with a foreign sovereign is subject to FARA, then if we go to a foreign country, and let's just hypothesize a foreign country that's a surveillance state that wants to surveil everything, then they pass something that's much more robust than FARA and just say, every time an embassy within our borders does any business with any third party, any documents they share are subject to surveillance by the government, subject to review by the government. Then would the FARA argument mean that then in that country that the Vienna Convention basically just doesn't apply, the inviolability principle just doesn't apply to any document, period, because there's this law, this hypothetical law that just allows for robust...
No, it wouldn't, because they're changing the expectations of the countries, of the parties, the Vienna Convention. The Vienna Convention was signed onto by these countries knowing that FARA existed.
I see. So it's temporally. The answer from your perspective is that law postdates, whereas FARA predated. And that's
so there I think there would be an argument that no, it does not override or.
So if there were a country that had that law beforehand, then
there would be an argument.
Then that would be the same situation.
Non-inviolability.
Across the board, even though it would be very robust non-inviolability.
Right.
Okay. There's no further questions.
Thank you.
Thank you, Mr. Benson. Thank you, Mr. Zients. We'll give you 3 minutes for rebuttal.
Thank you, Your Honor. Just a few quick points. One, on the comedy question, going back to Chief Judge Srinivasan's colloquy with Mr. Totaro. I agree that comedy does matter. Right now, the question before about, there's a limited remand, what is still open in the district court. There is a categorical ruling right now that comedy is not available, that the district court reached without looking at anything, without developing a record. The United States hasn't commented in this proceeding. It read the court's order is not requesting it. In the NML case in the Supreme Court, we think that what the United States said about comedy, and in particular comedy in the context of discovery targeted at third parties, is entirely inconsistent with the district court's categorical order. So in our view, that is a separate and important issue in this appeal that this should be resolved. And I endorse what Mr. Totaro said, that document of the mission is a particular phrase, particular construct. We think that will be quite protective on remand, but international comedy is a different way of getting at the protection in appropriate circumstances of sensitive governmental information. And it very well may be that there could be some close questions under the Vienna Convention where there is an easier answer once you get into the documents on comedy. So we think that the court, that is an issue that is presented for the court, and having the court send back on that issue would be helpful for remand proceedings. On jurisdiction, I don't want to, unless the court has questions, I don't want to belabor that point. I do just want to create a factual point that I believe Mr. Saunders said. He referred to the minute order of December 8th, 2021, as deciding that Qatar had amicus status. The court said that Qatar could file the equivalent of amicus briefs, but no pending motion requires addressing Qatar's exact status in this case. I don't think the district court ever changed that until it retroactively said in its final decisions here that actually Qatar really was just an amicus all along. So I think Qatar really was proceeding through this minefield without a compass, and it would be troubling for a foreign sovereign to have basically be deemed to have given up its rights under a treaty for not doing it one particular way. Finally, on the FARA points, going to the last point that was addressed about reciprocity concerns, this is not hypothetical. Russia has a FARA type law that has government audit and inspection provisions. And so I think, I would take seriously that the United States has not endorsed Mr. Broidy's position that FARA just vitiates any inviolability under the conventions. I think there is, I think we would, our view is that the best view is that inviolability could be argued in the case if DOJ came knocking, but the court really doesn't need to get into that. I think this consent concept exists in the treaty in Article 22. Inviolability of mission premises is rejected. The next sentence talks about the possibility of consent. It is possible that you could view sort of the decision to engage a contractor under FARA's regime, understanding that it is only law enforcement officers not concerned with snooping around in the sovereign secrets, but focused on enforcement of FARA, that could be a way forward, that at least be assumed to be correct in a way that doesn't undermine inviolability in this proceeding.
Let's suppose we find that the only path available to you is mandamus. Ordinarily, we deny mandamus unless there's some clear precedent that demonstrates that the district court's position was error, not for something where, or the district court, clearly used like there's a standard that's been articulated in the case law, and the district court did not use that standard. How do you meet that standard here?
Your Honor, a couple of responses. One, I think this court and others, particularly in the context of foreign sovereigns, has taken a more pragmatic view of the threshold for mandamus review. This court's decision in Papandreou, I think, makes that point, that when you talk about potential injury to a foreign sovereign, the court is going to be a little bit more forward-leaning in recognizing those types of arguments. This comes up also in context of executive branch privileges. We cited the Karnofsky case in the Ninth Circuit, where I don't think it was sort of clear error that normally might have triggered, but because of the fraud issues raised by the deliberative process issue in that case was reviewed on mandamus. That said, I think the normal standard is met here. We don't have this is a complex and novel issue. It is also one that at least now we have the United States government saying that this treaty interpretation by the district court was wrong. We had asked the district court, we think that you should defer decision until you go through a document by document process. We asked the district court, if you are inclined not to do that, this is really sensitive stuff and we think you should ask the government.
Did the defendants ask to do that?
Pardon?
Did the defendants make that request?
Your Honor, I don't recall that they did. I know that Qatar and its
But see, that gets me back to my problem, I guess, maybe as an old former district court judge and trial court litigator, is that like now you're wanting us to say that the district court erred because they didn't take an approach that wasn't put to it by a party.
Your Honor,
and amicus can't preserve issues.
Your Honor, I think I go back to where I started a few minutes ago. The district court didn't tell us that we were in amicus at that point. It said that I don't need to resolve your exact status yet. So I think we were just operating without guidance about what the best way to do this was. The issue is there. I really made that point only for the very limited purpose that we know now that the United States government, which is entitled to great deference in treaty interpretation, agrees with us that the district court was wrong. We had suggested that there was a way to find out the United States position earlier in the day. That was my limited point.
Thank you, counsel. Thank you to all counsel. We'll take this case under submission.